Dr. K. Yuvaneshwari, working as an assistant professor at PG Research Department of Commerce C at Comedy Arts and Science College, Satyamangalam. Today we are going to discuss a topic on commercial law. So, it is a small quotes about the law which is said by Aristotle. The only stable state is only which are men or equal before the law. All are equal before the law as per Aristotle quotes. So, what is commercial? Generally, it's related to the business or commerce. The activities, it is an commercial activities for selling and goods and services for a profit. So, history of law. The law is framed by the form of community enforced rules existed from the time people to started interacted, for example hunting, property, family relationship, responsibilities, etc. It is based on common sense and practice. It's passed by the word of mouth. So the Code of Hammurabi, the one of the most important areas records of written law. Hammurabi of Babylon had nearly they have framed 300 laws. They recorded in a way that citizens would understand them easily. Recorded the rules and penalties for every aspect of Babylonian life. It's reflected the pathetical society with the hierarchy of power. So as populations grows, as a society also grows, the laws becomes more complex. It becomes necessary to put these laws in writing. Many of the early laws and codes of law has an influenced Canada's present legal systems. So what is law? It is an instrument which regulates human conduct or behaviors. So introduction, what is law? It is social science, it grows and develops with the society. So new developments in society creates a new problem. So to deal with all these problems we require law. So law, it is some principles and regulations. It's set by and community some authority. It is applicable to people where in the form of legislations, customs, policies and enforced by state authority. Definitions. The juris defines different from different. It can be called dharma in Hindu and hukim in Islamic systems. Romance is called as an Jews and German and France is called as a research and direct responsibility. What Blackstone said about the law? It is a more general comprehensive sense. The set of rules of actions and applied discriminatory to all kind of actions to abolish gender, caste, language, race, birth, color and etc. They formed the laws. What Salman says about the law? The body of principles recognized and applied by the state in the administration of justice. The next, commercial law. What is commercial law? The common law systems is based on recorded judicial precedents. It came to India in British East Indian companies. The company granted chartered by King George I in 1726 to establish mayors courts in Madras, Bombay and Calcutta. In 1772, the first law came into India by British East Indian Company. So what is commercial law? It is also known as a mercantile law, trade law, or business law. It is a body of law that applies to the rights, relations and conduct of persons and business engaged in commerce, merchandising, trades and sales. It often is considered to be a branch of civil law and deals with both private and public laws. So what are the areas we have in commercial law? Business law, banking and finance law, commercial contract law, consumer protection law, intellectual property law and competition law. So what is contract? According to the section 2 of the Act defines a contract and agreement by law, that is contract equal to agreement plus enforceable by law. So all the contracts are agreement, but all the agreements is not a contract. So agreement which is not enforced by law, it cannot be a contract. So what is agreement? Section 2 of E of the Act, agreements refers to every promises and every set of promises forming the considerations of each other. Offer plus acceptance is called as an agreement. So promise. What is promise? Section 2, section of B of the Indian Contract Act 1872, a proposal which has been accepted, it becomes a promise. So classifications of contract. So we have in three kinds of classifications according to enforceability, according to the formations and according to the performance. So according to the enforceability, we have a void contract, void agreement, voidable contract, unlawful agreement, illegal agreement and unenforceable contract. So what is mean by void? The contract is not longer, it should not be, cannot be enforced by laws. What is valid? It is written or expressed agreement between two parties. Voidable, it is valid and is voided by the affected parties within the reasonable time. Void agreement. Section 2 of G, an agreement which is not enforceable law, that is an agreement with minor unsigned mind papers is considered as a void agreement. So void contract, an agreement to be carried out through an illegal act. The contract between drug dealers and buyers is a void contract. So unlawful agreement is not approved by law. Something should be an illegal. Purchase illegal drugs against public policies is considered as an unlawful agreement. Illegal agreement, violent public policies, unforceable contract. Sometimes a contract may become unforceable. Example, no signatures. Classifications of contract. According to the formations, we have an express contract, implied contract and quasi contract. Express contracts we have by words spoken or in written. It should be an usually it should be in written format, the express contract. Implied contract, it is to be exist but no written or verbal confirmations is necessary in implied contract. Quasi contract, it is created by court order. Classifications of contract according to the performance. Executed contract, contract has been completely performed, it's termed as an executed. For example, A agrees to repair B's car for rupees 500. A repairs car and B pays the survey charges, is called as an executed contract. The next, executory contract. It is a contract under the terms of contract. Something remains to be done by the parties. If A has repaired the car but B has not yet paid the charge, is called executory contract. Thank you.